Hello everyone, I'm Debujit Das and this is Quotes Today by LiveLaw. Before we get into our episode today, warm regards to our viewers who are celebrating Guru Nanak Jayanti and hopefully the year ends in peace and comfort. Without any further ado, let's look at the top stories today. We'll start with this ruling coming in from the Madhya Pradesh High Court where the court granted anticipatory bail to a man booked under the Wildlife Protection Act of 1972 for allegedly hunting and storing body parts of wild animals, specifically a peacock and a hare, without valid permission. The FIR was registered after authorities said the hunting took place in Forest Range Sevda on September 12, 2025, and the accused was alleged to have stored the body parts in his possession. However, the court noted major gaps in the prosecution's case. No clear evidence tying the accused to the alleged hunting spot exclusively. The recovery was from an open area, no independent witnesses, and no forensic proof that the seized items were wild animal parts. Based on these problems, the bench of Justice Milind Ramesh said the material did not show a risk of the accused fleeing from justice, and so the bail was allowed, without commenting on the merits of the case, of course. This ruling shows that while wildlife crimes are taken seriously, courts will still look closely at the evidence before denying bail, especially when there are serious lacuna in the case as presented. For our next story, we go straight to the Kerala High Court, where a Muslim man approached the court seeking registration of a second marriage under the Kerala Registration of Marriages Rules 2008. The issue here was that his first marriage was still valid and ongoing, and the registrar had refused to register the second marriage. The court said that even though Muslim personal law allows more than one marriage in certain situations, registration cannot proceed while the first marriage is subsisting unless the first wife has been notified and given a hearing. The judge stressed, Constitution is supreme, religion is secondary. The court added that the first wife's rights to dignity and notice cannot be ignored simply because the husband married again. The petition was dismissed, but the petitioner was told to reapply after properly notifying the first wife and ensuring a chance to be heard. In short, for a Muslim man to register a second marriage in Kerala under these rules, the first wife must be formally informed and heard, a crucial check on maintaining fairness in the system of multiple marriages. Moving on to the next headline, where the Delhi High Court raised serious concern over what it called a growing trend of sensational and misleading media reporting of court proceedings. The observation came while hearing a case involving senior advocate Vikas Pehwa, where several media outlets had claimed that adverse remarks were made against him during a hearing, even though no such comments were recorded in the official order. Justice Neena Bansal criticized this pattern of turning casual courtroom exchanges or passing remarks into a major headline, saying it distorts the essence of judicial proceedings. The court pointed out that not every comment made during a hearing reflects the judge's view or affects the outcome of the case, and yet such statements are often exaggerated or taken out of context to attract attention. The judge emphasized that courts rely on public trust, and irresponsible media coverage can damage reputations and mislead the public about what actually transpires in hearings. She reminded media outlets that while reporting on court proceedings is important for transparency, it comes with an equal responsibility to ensure accuracy and fairness. Next, we have an interesting development coming in where the case involved a privately owned land in Alandur, Chennai, where the Church of South India Trust Association had been using its patta land as a burial ground. A nearby developer by the name Stellar Developer, whose apartment project adjoined this land, challenged the license issued by the Greater Chennai Corporation on 27 February 2024, arguing that it was granted arbitrarily and in violation of several legal provisions. Justice N. Mala found that the license had indeed been issued in undue haste and without proper application of mind. The court observed that statutory rules under the Tamil Nadu Urban Local Bodies Act of 1998 and the Tamil Nadu Combined Development and Building Rules of 2019 had been bypassed. For example, the rules stipulate only one burial ground per subdivision under the building rules, a condition not met with in this case. The court also pointed out that the license fee was not fixed nor paid as required, and that the licensing committee included the very commissioner who later granted the license, a clear conflict of interest. Judge Mala held that this amounted to an arbitrary exercise of power and set aside the license. Importantly, the court ordered that all bodies buried on this land must be exhumed and reburied in a designated burial ground within 12 weeks, failing which the civic authorities and police at the landowner's cost shall carry out the exhumation. And for our final story, we have a case coming in from the Kerala State Consumer Disputes Redressal Commission. A passenger who booked an 11-day pilgrimage tour, the Astha Punya Tirth Yatra, organized by the Indian Railway Catering and Tourism Corporation or IRCTC, was unhappy with the service. He claimed that the train departed late, the coach was unclean, accommodations and food were inadequate, The schedule got cut short by 2 days and promised facilities like an on-board doctor were missing. The commission found the complaints credible. It pointed out that the train started from a different station than originally advertised, no proper arrangements were made during the delay, and there was no proof that passengers were properly informed of changes. The fact that the passenger rushed into the train despite the delay was taken as an indication that there was inadequate time to clean or prepare. As a result, IRCTC and the Southern Railway were held jointly liable for deficiency of service and unfair trade practice. The commission ordered a refund of 20,500 rupees and compensation of 50,000 rupees for mental agony and hardship. It also awarded 3,000 rupees as costs. In short, if you book a tour expecting a certain standard and the service falls short, delayed departures, dirty coaches, reduced itinerary, lack of promised facilities, consumer law holds that the organization and service providers will be accountable. That brings this episode of Courts Today to a close, but remember, if you want to access a detailed coverage of all the stories that we talked about today, visit livelaw.in and stay updated to all our socials like Instagram and Twitter to stay updated with everything that is law.